Be seated. Mr. Clerk, would you sound the docket, please?
2024 KA 1178 SCT Carly Madison Gregg versus the State of Mississippi.
What says the appellant? What says the state?
The state's ready to proceed, Your Honor.
Okay. Oops. Mr. Murphy, we'll hear from you.
Thank you, Your Honor. Good morning. Justices, may it please the court. My name is James Murphy, and it is my honor and it is my privilege to be here on behalf of Carly Madison Gregg. Here at co-counsel table with me is Lance Mixon, and we're both honored to be here as appellate counsel for Ms. Gregg. Now, this case is ultimately about whether a 14-year-old child received the fundamentally fair process the Constitution of the United States and the Constitution of the State of Mississippi requires before a juvenile can be sentenced to the most severe punishment, given the harshest sentence that the State of Mississippi can impose on a juvenile, and that is life without the possibility of parole.
Counselor, let me stop you there. I've read the sentencing order. The sentencing order in this case says that she's been sentenced to life imprisonment, which under the statute, and I think this is consistent with the argument you make on the sentencing issue, the statute, on subsection 2 of the sentencing statute for first-degree murder, gives two options. The jury can do life, can give life imprisonment, and if the jury doesn't, then the judge can assign a term of years. I don't know that I agree with you that this is a life without the possibility of parole sentence. The sentencing statute in subsection 3 seems to say there's life imprisonment. It doesn't seem to say, it does say there's life imprisonment, and then there's life without the possibility of parole or a term of years. So I'm reading this sentencing order, and to me, it's life imprisonment, not life without the possibility of parole. So why do you take the position that the sentencing order, what the sentencing order says is not what the sentence is?
Well, we would agree with Your Honor on that point, and if the state would concede that, I think we could make an easy argument of our sentencing argument here today. But I think the state's position is going to be that life sentence that was imposed by virtue of the parole statute imposes life without the possibility of parole. The jury in this case was given a sentencing instruction that gave them the option of sentencing Carly to life imprisonment or life with the possibility of parole. Now, by virtue of those two options, if they're not giving her life with the possibility of parole, by giving her life imprisonment, they are giving her life without parole. Those are just mutually exclusive options.
Well, I understand there's a separate parole statute in play here, and I can't remember the style of the case, but I know this court's issued an opinion that addresses the interplay between that parole statute and life sentences in other contexts. But just strictly speaking, or leaving the application of the parole statute out for a second, there are two options in that sentencing statute: life imprisonment and a term of years, and this sentencing order says a life imprisonment. So I don't see an inconsistency between the sentencing order or the legal sentences under the statute. And since that statute doesn't mention life without the possibility of parole as a legal sentence for this crime, I'm right where I am. I'm struggling to see why this is being interpreted as a life, other than the jury instruction, which admittedly doesn't match the sentence. But what we have in front of us, which is the order of the court sentencing Ms. Gregg, this is a life imprisonment sentence, which is consistent with the statute and doesn't seem to be without the possibility of parole.
And we would, yes, Your Honor, we would agree with Your Honor's interpretation of that. And again, if the state would concede that, we would certainly move on from that argument, but the state has argued in their response to our brief that by virtue of the parole statute, that life imprisonment judgment is in effect a life without the possibility of parole. And as I'm sure Your Honor and the court is aware, the legislature amended the first-degree murder sentencing statute 97-321, amended that statute effective July 1st, 2024, and added a juvenile-specific sentencing structure for both first-degree murder and capital murder. And subsection 2C, which deals with capital murder for juvenile convicted of capital murder after July 1st, 2024, it gives the jury two options, as I think Your Honor would concede. It gives the jury the option of sentencing a convicted juvenile to either life imprisonment or life without the possibility of parole. However, subsection 2B omits that option and only gives the jury the one option of life imprisonment. And I think that goes along with what Your Honor is saying. The first-degree murder sentencing options for a jury in a juvenile case only gives the jury the option of sentencing a juvenile to life. And by virtue of the legislature defining life without, or including life without parole in subsection 2C, and not defining life as life with parole, the only other option is that life imprisonment means life with the possibility of parole. So we would concede, Your Honor, that is the case. In fact, if the court interprets the amendments that way, we would concede that argument. But from March 19th, 2024, when the incident occurred, until the verdict and sentencing order were rendered on September 20th of 2024, this entire case, the entire case, from investigation to indictment to psychiatric litigation to motions filed to motions argued to expert evaluations to discovery to trial to sentencing, it proceeded in approximately 6 months, 183 days to be precise. In a medically and psychotropic medication evidence and dissociation case of this nature, that pace was extraordinary. And the accelerated pace of the proceedings affected virtually every aspect and major issue now before this court. And my first issue I was going to begin with was the sentencing issue, but as the court, I think we've discussed that. If there are any additional questions about that, we would argue certainly that the amended statute does not give a jury the option of sentencing a juvenile convicted of first-degree murder after July 1st, 2024. We would argue that the new amendments do not give a jury the option of sentencing, nor does a judge have the option of sentencing a juvenile convicted of first-degree murder, does not give them the option of sentencing her to life without parole. Now I will transition to the Miller issues. Again, we would argue that the new amendments, they pretty much make Miller obsolete in the context of sentencing a juvenile after the amendments, but assuming that the Miller progeny of cases is still in effect and is still the controlling law when it comes to determining what's proper sentence for a juvenile convicted of first-degree murder, we would propose that the Miller framework was not met in this case. The Miller requires individualized sentencing before a child may be condemned to die in prison. And again, we're operating under the assumption that the state's position is that Carly Gregg was sentenced to life without the possibility of parole. The proceedings here never became the careful, individualized juvenile sentencing hearing contemplated by Miller. The sentencing phase of this case, and again, this case went from the occurrence of the event on March 19, 2024 to the trial on September 16th, concluding on September the 20th of 2024. The sentencing phase, and I'm going to use that term loosely, the sentencing phase of this case consisted of the court announcing the verdict of the jury and then transitioning immediately to asking the state whether they wanted to call their first sentencing witness, to which the state responded that they basically wanted to rest on the evidence that had been previously presented and proceed with argument only. And the defense did the same thing. The defense elected to rest on the evidence that had been previously presented and proceed with argument only. Now, we would argue that this immediate pivot from the announcement of the verdict to the sentencing phase was wholly inadequate in light of Miller. There was no meaningful mitigation development process. There was no opportunity given to the defense to marshal mitigation witnesses. They were given no opportunity to call witnesses, family members, teachers, and as a matter of fact, as part of the pretrial process, the defense listed as one of the potential witnesses the grandmother of Carly Gregg. Miss Vicki Breland, who is also happened to be the mother of one of the victims, Ashley Smylie. She was listed as a potential witness, and she was not allowed to testify at the trial. So it stands to reason if she was not allowed to testify at trial, then the question then becomes, would she have been allowed to testify during the sentencing phase? And again, I use that term loosely because there was no meaningful opportunity to conduct a Miller-compliant sentencing hearing. There was no PSI, pre-sentencing investigation conducted, no report. The jury was exposed to confusing and inconsistent parole rhetoric by the prosecution at one point. And again, I'm going back to the sentencing hearing, which consisted of, and it's confusing, the record is confusing as to whether each side was given 7.5 minutes, 15 minutes total for their sentencing argument, or whether they were each given 15 minutes. At one point, it looks like the judge gave one side 7.5 minutes, and then the other side was given 15 minutes. So it's not clear to me from the record whether they were given 7.5 minutes to argue the sentencing phase or 15 minutes to argue the sentencing phase. But at one point during the state's argument during the sentencing phase, the state told the jury that if you give her, and again, this is going to the sentencing instruction that they were given the option of life or life with the possibility of parole. The prosecutor stood in front of the jury and told them that if you give her life with the possibility of parole, we don't know when she's going to get out. She might be out, and I'm paraphrasing here, she may be out in as little as a year, which I think we all know is outside the realm of possibility for a life sentence. But she may be out in as little as a year, and again, I'm paraphrasing, but you may see her at the supermarket, or you may see her at church. You may run into her at any place outside in public, and again, we would argue, and we argued in our brief, that that is improper golden rule rhetoric. It's appealing to the fears of the community, and that is improper. And I understand the state's going to argue and has argued in their brief that the defense failed to object to this, but notwithstanding that failure, we would ask this court to analyze that under the plain error doctrine and or pursuant to the ineffective assistance of counsel claims that we've made in our brief. We can see no strategic reason why a competent defense counsel would not object to that type of rhetoric argued in a sentencing phase. And in addition, even taking into consideration if the Miller progeny of cases is still the law and still applicable to juvenile first-degree murder and capital murder cases, the record is replete with examples of why there were mitigating factors. And we would submit that the juries, and again, assuming they sentenced her, they elected to sentence her to life without parole. And by the way, let me back up, I digress just a little bit. After the prosecution's statements about parole eligibility and when she might be out within a year, and you might run into her at the supermarket, after the jury began their deliberations, almost immediately after they began their deliberations, we know that parole was on their mind and how long she's going to spend in jail if she gets granted parole eligibility, because they submitted a question, and I'm going to paraphrase this too, if Carly is granted parole eligibility, if she's given life with the possibility of parole, which is one of the two options she was given by the court, if she's given life with the possibility of parole, how long will she serve years-wise? So we know that was on their mind. We absolutely know that was a question that they had in their mind going into deliberations. Nothing minimizes the horror of what happened to Ashley Smylie or the trauma suffered by Heath Smylie. Nothing minimizes that. But Miller requires courts to distinguish between irreparable corruption, incorrigible youth, and transient immaturity before condemning a child to die in prison. And again, assuming that the state's position is correct, that she was sentenced to life without possibility of parole, that is exactly what she was done. She was sentenced to die in prison, because if she's not eligible for parole at any point, then she will pass away in prison, and that's in effect a death sentence. And I want to read
Mr. Murphy,
from a brief.
Mr. Murphy,
Yes,
let me
Your
just interrupt you there for a second. I want to clarify something for purposes of I know this court has written that for purposes of the application of that parole statute, the one that forbids parole for people guilty of first-degree murder, we have held in the Miller context that is the same as a life imprisonment. So But you've still got, I think you conceded, not just as to those comments that were made by the prosecutor, but also as to the hearing itself and the brevity of the hearing, et cetera. There were no objections made by defense counsel that would have preserved that issue for appeal, were there?
No, Your Honor, there were no objections. And as to that issue, Your Honor, a case that we cited in our brief, Presley v. State, which is 474 Southern 2nd 612, a case that was decided by this court in 1985, a case where the sentence was vacated. And in that case, a pre-sentence investigation report had been prepared and submitted to the court. The trial court offered defense counsel the same as apparently the trial court did in this case, gave defense counsel the opportunity to present mitigation, and defense counsel nevertheless failed to meaningfully develop mitigation evidence. And the court, in that case, vacated that sentence based on the rationale and the holding that, and I'm going to quote from the Presley court, "We recognize that there are cases, even where the appellant and his attorney fail to prepare and complete a sentencing record, as was done in this case, or not done, as the case may be, where the trial court must consider all facets, background, and record in a sentencing hearing in order that a just and proper sentence may be imposed." So we would submit to Your Honors that this court has the power to impose that duty on the trial court just as it would impose the duty on the defense counsel. And even barring that plain error submission that we are offering here today to give the court the authority to review that, again, I think we've offered the Strickland v. Washington ineffective assistance of counsel claim. We can fathom no strategic reason why defense counsel would not want to ask for time.
Is this court in a position on this record to evaluate the prejudice prong of Strickland, not knowing what mitigation evidence might have been discovered had that work been allowed to proceed?
I believe that we could evaluate the prejudice prong based on what we know about what had been presented earlier in the case. We had two forensic psychiatrists who testified in this case. And I believe even the state's forensic psychiatrist opined that Carly was not a psychopath, that she was not evil, and that she came close, and I'm paraphrasing here, that she came close to the evaluation needed to reach the McNaughton standard. Even the state's own psychiatrist stated as such. And then you had the defense psychiatrist who found that she did meet the McNaughton standard. So the failure of the defense counsel to at least recall those witnesses to testify in the context of a sentencing phase would clearly be prejudicial. To bring out those points that they had made earlier in the proceedings to specifically apply to the sentencing phase, I believe that's absolutely prejudicial, Your Honor. In addition, the issues that I brought up earlier, the witnesses, the lay witnesses that could have been marshaled and provided, the family members that I believe are here today and that were prepared to testify on behalf of Carly in the sentencing phase, teachers, friends, all of those things, as far as we are aware and as far as the record reflects, they would have all testified on behalf of Carly and would have provided positive mitigation evidence on her behalf. So yes, Your Honor, we would submit that the record is sufficient to evaluate the prejudice prong of the Strickland analysis. Now, outside of the sentencing issues that we've discussed, Your Honor, the trial court announced at the very first interaction between the trial court and the litigants in this case, announced not once, but twice, that this court does not continue cases. And it even mentioned that y'all have heard me say this before today, that this court does not continue cases. Now, that posture shaped the atmosphere of the litigation from the very beginning. Now, you may ask, is that in and of itself, is that an abuse of discretion? And we would offer, and we cited Leonard v. Leonard, where A discussion was had of whether a court can issue blanket denials of continuances, and that court held that it is abuse of discretion to prejudge and pre-rule that there are no continuances allowed under any circumstances. And that we would submit that is exactly what the trial court did in this case, announced from the outset that there are no continuances going to be granted. Now, the state offered in their response brief that this was not a blanket denial of continuances. This was just an attempt by the trial court to prevent dilatory tactics of the litigants. But, Your Honor, looking at the four corners of the transcripts, we saw no caveats issued. There were no continuances unless so-and-so happens. No continuances unless there's a darn good reason. There was none of that. It was a blanket denial of continuances. Well, then the state's going to submit to the court. Well, the defense never asked for a continuance. So there's no harm, no foul. It's harmless error. Even if it's error for the court to issue a blanket denial of continuances, that error is harmless. But to that, Your Honor, we would offer a plethora of cases, including Mississippi Rule of Evidence 103C, that says no further objection or offer of proof is required where the court's ruling is definitive. Smith v. State, which we cited, 724 Southern 2nd 280, preservation rules do not require actions that would serve no practical purpose.
Mr. Murphy, without any motion being filed, exactly what do we have in the record where we could say that it was an abuse of discretion not to grant a motion for continuance?
Well, it was not necessarily an abuse of discretion to not grant a motion for continuance because obviously, as we would concede, there were no motions for continuance.
But I mean, are there any reasons for a continuance? I haven't even heard you argue whether there were any reasons for a continuance that were considered, contemplated, and not requested. You're just simply asking, as a statement of law, for us to find the trial judge in error because he made a statement.
Well, Your Honor, and again, going back to this line of cases that basically says a litigant, a defense attorney, or any attorney is not required to ask for something he knows he's not going to get in order to preserve error. That's exactly what Mississippi Rule of Evidence 103C says. Further objection or offer of proof required where the court's ruling is definitive. There is no requirement.
Counselor, further objection seems to indicate that there was an objection initially. So I think those cases that you're citing, in those cases and the text of that rule, still seem to require an initial objection or motion that is denied. I know that Leonard versus Leonard, there was a motion that was denied. That's what the court was reviewing for error, was the decision. So, I mean.
And I think the rules of civil, at least the rules of civil procedure, required that any request made to the court be made by motion, written motion before trial or during trial, and oral motion. And so even, I hear your argument, but I don't hear you saying any reason why this was error.
Well, Your Honor, it was error because number one, it chilled the litigants. They I hate to say afraid perhaps, but, and going back to Smith versus State,
I'm not sure anybody was chilled in this case. Just reading the transcript, it seems to me that there was very active participation in this case by the lawyers. And certainly there's no reason a motion couldn't have been made, but I'm just wondering, you know, give me some basis for the continuance.
Well, Your Honor, and this is getting into the orders for psychiatric evaluation, which we think were premature and beyond the scopes of Mississippi Rules of Criminal Procedure. The litigants, they were very active, Your Honor. It appears that they were bending over backwards to abide by the court's, for lack of, and I put it in my brief, so I'm going to say it here today, rocket docket. Announced that this trial is set for trial September 16th, and there's absolutely no reason that we see that this trial can't go forward. So everybody was bending over backwards to accommodate that trial schedule.
As they should, though, isn't it? I mean, that's what we want, is a speedy trial. We have so many cases come through here where it's delayed and delayed and delayed, and now we have one that's moving quickly through the system, which is supposedly the way it's supposed to work. And there's no basis in the record to say a continuance should have been granted.
Well, it was continuing in a speedy fashion at the expense of Carly's constitutional rights. The trial court ordered her to undergo competency and insanity at the time of offense evaluations before the 17.4 threshold of announcing the insanity defense had been met. And that is simply not what the rules contemplate. And in fact, the defense attorneys in this case filed a petition for interlocutory appeal to appeal that ruling. Her constitutional rights were we would submit, trampled on because they were ordered to turn over privileged information, medical records that they would not have otherwise have had to turn over to the state, but for the insanity defense, which at the time they were ordered to be turned over, had not been properly put before the court. Sure, the defense counsel at one point said that we intend to assert an insanity defense, but with all due respect to all of the attorneys that were involved in this case and even the trial court, none of us are psychiatric or forensic psychiatrists. And so for me, as a defense attorney, to announce at the beginning of a case before my client has even been evaluated by a forensic psychiatrist, and for me as a defense attorney to say we're going to assert the insanity defense, I believe is malpractice. Because I don't know what an evaluator is going to say once that evaluator reviews all the records and interviews Carly and makes a determination as to whether she has met the Monotony standard. So they were forced, they were given a Hobson's choice to either turn over those records and waive the privileges that go along with turning over those records, or waive the defense altogether, and they chose to preserve that defense. And until and unless they file the 17.4 notice of insanity defense, the court does not have the power, to order Carly to undergo psychiatric evaluations at the behest of the state. The court...
Does that apply? Okay, so the state made a motion, as I recall. Correct me if I'm wrong on this, because there's a lot going on in this record.
Yes, Your Honor.
And the court granted the state's motion and sent Ms. Gregg for evaluation, both as to competence to stand trial and the McNaughton issue.
Correct, Your Honor.
But the psychiatrist, counselor, I don't remember which, to whom the court sent Ms. Gregg for that evaluation, reached an opinion as to competency to stand trial, but declined to issue an opinion on McNaughton. Is that correct?
The initial state's expert, yes, that is correct.
All right. Does the fact that that expert declined to address McNaughton or issue an opinion on that affect your argument that it was wrong to send her for that
Well, the
evaluation?
only reason she declined to render an opinion was because there were some issues with marijuana or some other...
Whatever the reasons were,
Right.
Does that affect your argument that it was incorrect for the trial judge to
It
order that?
absolutely does not affect my argument. That was premature, and that was incorrect and outside the court's power to order that exam at that point in time.
And you're saying that the harm that resulted from that is that it gave the defense's strategy up too soon and forced the defense to disclose documents it wouldn't have otherwise yet disclosed?
Among other things, yes, Your Honor.
But those documents would have been disclosed because the defense did pursue the insanity defense.
Yes, Your Honor. If the defense had ultimately chose to pursue the defense of insanity, those documents would have been produced. But if the rules had worked the way they're supposed to have, and the timing had worked the way the rules require, then the defense would have had Carly evaluated by their expert, who would have reviewed all those records and interviewed Carly and made a determination, yes, she qualifies for the McNaughton insanity defense, then you hand it all over. But if that, in contrast, if that evaluator and that expert had said, no, she does not qualify, then the state does not get the benefit of those privileged documents. The state does not get to have their expert evaluate her. So by jumping ahead and then ordering that the state gets to evaluate her ahead of time, it inverts the whole process. It gives the state access to documents that they may not have otherwise had access to. And with those privileged documents, of course, come waivers of communications that Carly had with her treating physicians and psychiatrists and counselors, among other things. And I think everyone would recognize, I think that we'd ask the court to take judicial notice that each evaluation of somebody would affect the next evaluation. And by virtue of the state having the first, I believe the state had the first opportunity to evaluate Carly because the defense's first expert was taking more time to evaluate her than was initially anticipated. And going back to that, they certainly weren't outside of their time limit. According to Rule 17.4, the defense has until the time for filing pretrial motions to assert the insanity defense. And in this case, the court's pretrial motions deadline was August 30th of 2024. The court started pressuring the reports back in June or July of that summer, well before the pretrial motions deadline of August 30th. So the court entered the order July 3rd that she submit to a state expert evaluation.
Okay, Mr. Murphy. Are there any other questions of Mr. Murphy at this time? Okay. All right, thank you, Mr. Murphy.
Thank you. How much time do I have? May it please the court. I'd like to address a couple quick points, if I may, before I move on to some more substantive argument. I believe it was Justice Sullivan who asked counsel whether the legislature could have, whether it's possible that the legislature intended for life in subsection 2B as it applies to juvenile first-degree murder, whether the legislature could have intended that that be life with parole irrespective of the parole statute, and counsel responded, possibly. I think that is very telling, in that I think at the very least, while we would assert that it very certainly does indicate that the legislature intended that, but we would assert that the state has now conceded at the very least that there is some ambiguity as to whether the state or the legislature intended that or not. And as I think the court is well aware, the brief that we cited, we included all of the canons of construction when the court is interpreting statutory construction, and one of those rules is the rules of leniency. And the leniency rule states that if there is a distinction to be made, if there is an ambiguous statute, and there are two interpretations, the interpretation that is most lenient to the defendant is the one that the court must adopt. And in this case, that adoption would be that the statute that was amended in effect at the time of the sentencing is that Carly's sentence is life with the possibility of parole. I'd like to make that quick point. And also, Your Honor, I'd like to address, Your Honors, I'd like to address the state's reliance on Johnson v. State. 2 points I'd really like to make about that and why the state's reliance on that is misplaced. Number one, I believe it was Justice Coleman who pointed out that was decided well prior to the amendments to the statutes and in response possibly to Miller. But that case involved a very thorough Miller sentencing hearing. And that is distinguished from this case because there was no Miller sentencing hearing. There was, and again, I've used that term loosely, there was a sentencing hearing, but that was very, in effect, it was a sentencing argument. So in the case at bar, unlike in Johnson, we had no sentencing hearing, and I believe Miller not only stands for the proposition that there are certain factors that a jury or a trier of fact or whoever's deciding the sentence must consider. You can't just throw all these factors that the jury must consider at the wall and assume that they're going to consider them. So there's a substantive aspect to Miller, but there's also a procedural aspect to Miller. In other words, is the defendant given adequate process, adequate notice, and an adequate opportunity to address those Miller factors? And in this case, there was absolutely no notice that we're moving into the sentencing phase. I'm not even sure, prior to the court turning to the state and saying, present your first sentencing witness, I'm not sure whether the litigants were even aware that that was going to happen. I certainly don't see anything in the record where the sentencing order or anything like that outlined that that was going to happen. But certainly the defense was not afforded any due process to address those Miller factors. And so we would move or posit that Johnson is really inapposite to Carly's case. Another issue that we would point out, and I'm just going to read from our brief, the state's reliance on Johnson v. State is misguided. According to the state, and I'm quoting from the state's brief, this court held in Johnson that the trial court's application of section 4773 to sentence Johnson, who was 17, when he committed first-degree murder to life imprisonment without the possibility of parole after a Miller hearing was not an abuse of discretion. Thus, in harmony with Miller, Section 97.3.21.2b allowed Carly Gregg's jury to sentence her to life without parole consistent with Section 47.7.3d, which is a parole statute, but only after it considered the Miller factors. However, the trial in Johnson occurred in 2000, as I think Justice Coleman and Justice Sullivan and perhaps a couple of other justices pointed that out. The trial in Johnson occurred in 2000, nearly 2.5 decades prior to the amendment to 97.3.21 from Senate Bill 2022 of our 2022 of our legislature's regular session in 2024. And now, if I may, we did not address this in the initial argument, but I would like to address one of the errors that we have alleged that the defense did object to, and that was the introduction of the crime and punishment summation by Rebecca Kirk, who was one of Carly's counselors. During the state's rebuttal case, the state elicited testimony from Rebecca Kirk, who was, again, one of Carly's counselors, to summarize. Well, first she was asked what books Carly had read or was going to read, and there were several books that were mentioned. One of them was The Bell Jar, another was The Castle, and then there was Crime and Punishment. Curiously, the state did not ask Rebecca Kirk to summarize The Castle or The Bell Jar. The only one that they asked Rebecca Kirk to summarize was Crime and Punishment. And this was over objection of defense counsel. And this was over objection of defense counsel after pointing out to the trial court that there's no proof that Carly even read the book at the time of the trial. Now, we would dispute whether or not that was ever established. I think in cross-examination, I think defense counsel got Ms. Kirk to admit that maybe she said she was going to read it, but she hadn't definitively read it or not. But whether she had read the book or not is really irrelevant. The plot of that book was a sensational plot that, as summarized by Rebecca Kirk, it was about a hatchet-wielding murderer who tried to assert the defense of insanity and then got away with it and was unremorseful and unrepentant. That was the summation of Rebecca Kirk. Now, not only would we assert that that was an incorrect recitation of the actual book, but at the very least, it was the important points that Rebecca Kirk remembered about the book. It was not the important points that perhaps Carly Gregg would have remembered about the book. But be that as it may, the only reason that the prosecution would want Rebecca Kirk to summarize that book is because the prosecution wanted that jury to hear those sordid details about that book and associate those details with Carly Gregg. They wanted the jury to think, well, if she read that book, she must have been she must have had those thoughts, and she must have hatched the plot to plead insanity after she read that book. That is exactly what the prosecution wanted the jury to believe, and that was over the objection of the defense. Now, I believe it was Justice King, and I believe Justice Coleman joined Justice King in an objection in Jordan v. State, which was an en banc split decision by this court rendered in 2016, which was reviewing a affirmation of an appellate court. The Court of Appeals affirmed a finding of guilt after the prosecution was allowed to introduce rap lyrics. The Court of Appeals affirmed the conviction, and then the Supreme Court was split evenly 4-4. Again, I think Justice King filed an objection. Justice Coleman, I believe, joined in that objection. And there were several things that Justice King cited in his objection. And I believe that court cited with approval a New Jersey case, State versus Skinner. In that holding, in State versus Skinner, the New Jersey Supreme Court held that lyrics were highly prejudicial and carried little or no probative value because they were expressive, fictional writings and not tied by a strong nexus to the charged shooting in that case. Just as in this case, there is no nexus between what the writer of Crime and Punishment wrote and what was alleged that Carly did. There was no nexus. It was not even established that she had read the book. And I want to read a quote because I think it's extremely instructive from State versus Skinner. The difficulty in identifying probative value in fictional or other forms of artistic self-expressive endeavors is that one cannot presume that simply because an author has chosen to write about certain topics, he or she has acted in accordance with those views. One would not presume that Bob Marley, who wrote the well-known song I Shot the Sheriff, actually shot a sheriff, or that Edgar Allan Poe buried a man beneath his floorboards as depicted in his short story, The Telltale Heart, simply because of their respective artistic endeavors on those subjects. The defendants, in that case, lyrics, should receive no different treatment. In sum, we reject the proposition that probative evidence about a charged offense can be found in an individual's artistic endeavors, absent a strong nexus between the specific details of the artistic composition and the circumstances of the offense for which the evidence is being adduced. And I would take that a step further. That case and these cases that we cited in our brief, including Jordan v. State, Brooks v. State, United States v. Curtin, involved artistic works that the defendant was alleged to have written or participated in some form or fashion. In Carly's case, the artistic work at issue is a book that she had absolutely nothing to do with writing. She did not write that book. She had absolutely no contribution to the themes that were found in that book. So we would submit that the propositions cited by Justice King in Jordan v. State, by the Jersey Court in State v. Skinner, by the Ninth Circuit in United States v. Curtin are even more applicable in the case at bar than they were in those cases. And we would argue that the court erred in allowing the state to introduce that testimony.
Thank you, Mr. Murphy.
And if there are no other questions by the justices, thank you, Your Honors.